I may be pardoned, my lord. Contempt application, contempt petition, phrase, second memo, second memo.
But phrase criminal appeal courts, it will take next week.
Day after tomorrow. Day after tomorrow.
After tomorrow is a working day.
Holiday. Sorry.
Yeah.
That's it, phrase admission.
Yeah.
Supplemental list, item number 1.
May I please?
Yes, Mr. Padi.
My lord. The last occasion, my lord, regarding question an extrajudicial confession.
More of paper with the go down.
Into 9 minutes.
ये फाइनल हियरिंग का नाम रहेगा पर
ठीक है घंटे आइए
ये सारी का
My lord, draw my lord's attention. PW7 Nishakar Pradhan, my lord. We threatened him to call police. Hearing the name of the police, the accused disclosed the murder. Hence, he informed to Punjabihari Sahoo, PW for confessed out of a threatening. Nishakar PW number 7, my lord, page 71. There is another path. Good path. But the PW7 says, my lord, there is another path road from village Kanpur to Kanhar Hill. My lord, page 10, PW10, my lord, page 79, Ekasi, Jitendra, para 7. I had no acquaintance with the accused, and para page 8, there is the disease produced with this.
On what point you are arguing?
It is extrajudiciary confession. My lord.
Just a minute. Extrajudicial confession issue has been dealt by the Learning Trial Court in page number, internal page is 20, running page is 22. You come to that.
My lord.
That is paragraph number 15.
Page 20.
22.
22.
Running page is 22, internal page is 20.
But it starts from para 15.
Para 15.
Circumstances number VI. Circumstances number VI.
पढ़ो.
The accused made extrajudicial confession before PW7, 10, 11, and 14 to have murdered the deceased and burnt his dead body, and he was detained by PW7, 10, 11, and 14. The police was informed over telephone and after arrival of the police FIR.
पढ़ो तो अरे कौन जो analysis के
My lord, to prove these circumstances, the prosecution has also relied on the testimony of PW7, 10, 11, and 14. All the 4 witnesses have categorically stated in their evidence that when they noticed the accused coming from the Kanhar hillock by covering his face by a Turkish towel and his wearing apparels were stained with blood. Suspecting some foul play, they asked the accused about the same, and although he first remained silent when they threatened him to call the police, the accused confessed before them to have murdered the deceased by means of a sharp cutting knife and burnt the dead body at the spot. Thereafter, they informed the matter to one Punjabihari Sahoo PW4, and after arrival PW4, the accused took them to Kanpur hillock and stored the dead body.
Hillock and showed the dead body.
Fine.
Fine.
To the learned public prosecutor during his argument submitted that although the witnesses have given threat to the accused to call the police, it cannot be said that such confession was not voluntary. But under threat, since there was no police personnel present at that time, therefore the prosecution has successfully succeeded in proving the extrajudicial confession made by the accused. In replies criticizing the submission made by the learned PP and the learned SDC submitted that out of a fear of police, he confessed his guilty and it cannot be said voluntarily. Admittedly, PW 7, 10, 11 and 14 gave threat to the accused to call the police, and after the accused confessed his guilty to have committed the murder of the deceased at Konarpur hillock, and so saying, he took the witnesses and PW4 who reached the spot of the picnic on getting telephone call to that place and showed the dead body of the deceased, which was about 75% burnt. Thereafter, PW4 informed the police over phone, and after arrival of police, PW14 lodged the written report before him. Thus, it is clear that at the time of extrajudicial confession made by the accused, no police personnel were present. There, moreover, except a mere threat of calling the police, no other grave threat or assault was made by the witnesses to accused. There was no evidence or reason to show that PW 7, 10, 11 and 14 had any prior enmity to settle score with the accused to falsely implicate him in a case like murder, and only to know the real truth, they threatened the accused to call the police. So the extrajudicial confession cannot be said to be tainted. The Honorable Apex Court, referring to various decisions of the Honorable Supreme Court in recent decision in case of Jagrup Singh versus State of Punjab, reported in 2012, 53 OCR, AC there held the under. Extrajudicial confession. It is the settled position of law that extrajudicial confession, if true and voluntary, can be relied upon by the court to convict the accused for the commission of the crime alleged. Despite inherent weakness of extrajudicial confession as an item or evidence, it cannot be ignored when shown that such confession was made before a person who has no reason to state falsely and his evidence is credible. The evidence in the form of extrajudicial confession made by the accused before the witness cannot be always termed to be tainted evidence. Corroboration of such evidence is required only by way of abundant caution. If the court believes the witness before whom the confession is made and is satisfied that it is true and voluntary made, then the conviction can be founded on such evidence alone. The aspects which have to be taken care of are the nature of the circumstances, the time when the confession is made, and the credibility of the witnesses who speak for such a confession. that apart before relying on the confession, the court has to be satisfied that it is voluntary and it is not the result of inducement, threat, or promise as envisaged under section 24 of the Act brought about the suspicious circumstances. Circumstances section 25 and 28. I have already discussed above. There is no reason PW 7, 10, 11 and 14 had any acts to grind against the accused to implicate him falsely in such a grave crime like murder. Had he not committed the crime, then what promoted him to confess his guilty to the crime and take the witnesses to the spot of murder and show the dead body of the deceased? In these premises, the confession made before the aforesaid witnesses should be given credence and it should not be thrown overboard on the ground that the witness threatens the accused to call the police. Therefore, the confession made by the accused PW 7, 10, 11 and 14 was not a tainted one and it is an incriminating circumstance against the accused.
So, the learned trial court found that from the evidence of these 4 witnesses, there are material that they threatened the appellant. But all the same, the learned trial court held that since no police personnel present and there is no evidence of prior enmity of these 4 witnesses with the appellant to falsely implicate him, and then this mere threat of calling the police cannot be a ground to disbelieve the extrajudicial confession. That is what has been observed in this paragraph. What is your submission?
My submission is there is a threat. It is minor voluntary and it is not the result
lined
of
up for it.
inducement.
Please come to that particular line of all these 4 witnesses. Let us see that what they have actually stated. In particularly ସେଇଠି ଅଛନ୍ତି ଯୋଉଠି extrajudicial confession ବିଷୟରେ କୁହାଯାଉଛି PW 7 କୁ ଆସନ୍ତୁ।
Minor.
4ଟା ତ witness ନା
Minor.
7, 10, 11, 14
Minor.
7 ରୁ ପଳେଇ ଆସନ୍ତୁ।
PW 7 page 71.
You come to page number 72.
Minor. 72 minor.
72 ର second line କୁ ପଳେଇ ଆସନ୍ତୁ।
last line ଟା
पेज 2 सेटा जोटा
we doubt.
ହଁ
We doubted same found three.
ହଁ ମୁଁ ସେଇ ତ ସାରି
तो पारा 3 तो
ହଁ ସେଇ ପାର ହଁ ପଢନ୍ତୁ
72 page minor.
पहले की पारा 3 ताका
ସେଟା ପାରା 3 ର
Minor. Minor.
आरंभ
71 last.
ଆରମ୍ଭ ପାରା 3 ରୁ ଆରମ୍ଭ କରନ୍ତୁ ଠିକ ହଁ
We doubted some foul play and asked the accused
ସେ ଯେତେବେଳେ ଟାୱେଲ ଘୋଡେଇକି ଯାଉଥିଲା ସେ ଗୋଟେ କଣ ବେଗ ଧରିକିନି ସେଇଥିପାଇଁ ଡାଉଟ କଲେ ହଁ ତାପରେ ପଢନ୍ତୁ
that
आफ्टर डिटेनिंग
minor accused after detaining him, but the accused did not give any reply. We also found the wearing apparels of the accused were stained with blood and also injury on his left thumb. Then we threatened him to call the police. Hearing the name of police, the accused stated before me and other that he had taken 10,000 as loan from the deceased, and when the deceased asked for repayment of the loan, he planned to murder the deceased. Accordingly, he accused took the deceased to Conhar Hillock and murdered him by means of sharp knife, by cutting his throat, and thereafter burnt the dead body, collecting dried leaves.
So this is the extrajudicial confession part,
My lord,
right?
my lord. There is the word threatening. सेता
ହଁ ନାଇଁ threatening ଟା କଣ କହିଲା ଯେ ଆମେ
पुलिस की डाकिबु से भୟରେ
पुलिस को डाकिबु ताकू धमकी नांती तू जदी
ना थ्रेटन करसंती.
सुनंतु that threaten is what?
My lord.
Is it a personal attack that you will be murdered if you will not say? We will kill you if you will not say?
ସେତା ହାତ ବାନ୍ଧି ଦେଇଛନ୍ତି ତାଥିରେ ଅଛି ହାତ ବାନ୍ଧି ଦେଇଛନ୍ତି.
କାର
ସେଇ ଯୋଉ ଆକ୍ୟୁଜଡ ହାତ ବାନ୍ଧି ହେଇଛନ୍ତି ଗାମୁଛାରେ
କାହିଁ କୋଉଠି
ଅଛି, ମୁଁ ଆସିବି।
ଆସନ୍ତୁ
ଆପଣ ଆସିବେ
ଆସନ୍ତୁ ଯେ।
ନା ଏଇ ଯୋଉ 7 ର only there is what my lord has rightly pointed out, threatening.
ଟ୍ରାଏଲ କୋର୍ଟ ବି ସେଇ ଜିନିଷ କହିଛନ୍ତି। ଆପଣଙ୍କର ଯଦି ତାକୁ ଗୋଟେ ଥ୍ରେଟିଂ ଦେଇଥାନ୍ତେ, ମନେ କରନ୍ତୁ ତୁ ଦୋଷ ମାନୁଛୁ ନା
ତତେ ଆମେ ଦେଖିଦବୁ।
ଦେଖିଦବୁ, ନହେଲେ ତୁ ଦେଖ ତୁ ଯଦି ଦୋଷ ମାନିଯିବୁ ତତେ ଆମେ କିଛି ଇଏ କରିବୁନି, ତ ଅନ୍ୟମାନଙ୍କୁ ଇଏ କରିଦବୁ, ଏମିତି କିଛି କରିଛନ୍ତି, କିଛି ଇଣ୍ଡ୍ୟୁସମେଣ୍ଟ କରିଛନ୍ତି। ଯଦି ତୁ ଦୋଷ ମାନିଯା ତତେ ଆମେ ଏତେ ଟଙ୍କା
Allurement କି
Allurement।
allurement ଅଛି କି inducement ଅଛି, it is just the word must have been used has been used as threatening, but it is a caution. In a way, if you will not tell, we will tell the police.
ପୋଲିସ
ଏ ତ ସାଧାରଣ କଥାରେ ଏଟା କୁହାଯାଏ ଯେ ଯଦି ନ କହିବୁ ସତ ତାହେଲେ ମୁଁ ପୋଲିସକୁ କହିବି।
ନାଇଁ ଏଠି ବି ସେତକ ବି କହିନାହାନ୍ତି, ଖାଲି
ସେତିକି ବି।
କହିଛନ୍ତି ଦେଖିଛନ୍ତି ଯେମିତି
କହ କଣ
ୱେରିଂ
କରିଛୁ?
ଆପେରାଲ୍ସ
Yes.
ତାକୁ ଦେଖିଛନ୍ତି, ତାକୁ
କଣ
ସନ୍ଦେହ
ହେଇଛି
ହେଇଛି
ବୋଲି
କଣ
ପଚାର,
ହେଇଛି, ମାନେ ପୋଲିସକୁ ଡାକିଦବୁ।
ସତ କହ ବୋଲି ବି କିଛି କୁହାହେଇନି।
ନା ସେତିକି ବି ସେ କହିନାହାନ୍ତି। ତାପରେ ସେ ତାର କହିଦେଇ ଚାଲିଛି ଯେ ମୁଁ ଏଇଆ କଲି
They
ଏବଂ
doubted because both were proceeded together.
No, not only that, there were
ତାର ଦି- ଦି
several
ଜଣ ଏକାଠି
other
ଯାଉଛନ୍ତି।
appearances.
ଫେରିଲା ପରେ ତାଙ୍କର ଡାଉଟ୍ ହେଲା।
Not only that, from the gesture of the accused, there were suspicions. He was going in a different way. There was blood stains. So,
There were cover
keeping this
his
in
cover his face.
କଭର କରି
ହୁଁ,
ବ୍ଲଡ ଷ୍ଟେନ୍
ପଳେଇ ଯାଉଥିଲା ସେ।
କରି ପଳେଇ ଯାଉଥିଲା, ତାଙ୍କର ସନ୍ଦେହ ହେଲା,
ହଁ,
ରଖିଲେ ତାକୁ। ପୋଲିସକୁ ଡାକିଦବୁ ବୋଲି କହିଲାଠୁ ଇଏ ତାର ଏଭିଡେନ୍ସ ହଉଛି ସିଏ କଲା, କିନ୍ତୁ ଏଥିରୁ ଜଣା ପଡୁନି ଯେ ତାକୁ ଧମକେଇଛନ୍ତି
ନା।
ଦୋଷ ମାନିଯା ବୋଲି, ଯୋଉଟା କି ଟ୍ରାଏଲ କୋର୍ଟ ଡିଲ୍ କରିଛନ୍ତି। And what have you brought out in the cross examination that on this threat aspect, ଯାହା ପ୍ରଶ୍ନ ପଚାରିଛନ୍ତି, ଏଇ ଯଦି ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଟା ବିଲିଭେବୁଲ ହବନି ବା କହିନି, ଏମିତି କିଛି ବାହାରିଛନ୍ତି, ମାନେ କରିଛନ୍ତି କି ତା ସାଙ୍ଗରେ ପ୍ରିଭିୟସଲି କିଛି ଶତ୍ରୁତା ଥିଲା ଯୋଉଥିପାଇଁ ତାକୁ ମିଛରେ ପକେଇଛନ୍ତି, ଏମିତି କଣଟା କ୍ରସ୍ ଏକ୍ସାମିନେସନ ବାହାର କରିଛନ୍ତି।
Cross examination, my lord,
ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ
Fine.
ଉପରେ
କେବଳ ପାରା 12 ଆଉ କିଛି ନାହିଁ।
ଖାଲି ଗୋଟେ ସଜେସନ, ଯାହା ପାରାଗ୍ରାଫ 12 ଛଡା ଆଉ କିଛି କୌଣସି ଲାଇନ ଗୋଟେ ବାହାର କଲେ ଯୋଉଠିକି ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଟାକୁ ଆପଣ କୌଣସି ମତେ ଚ୍ୟାଲେଞ୍ଜ କରିଛନ୍ତି ବା କିଛି ବାହାର କରିଛନ୍ତି, ତାକୁ ଡିସବିଲିଭ କରିବ କୋର୍ଟ,
ହସରେ କିଛି।
ସେଇ ପର୍ଯ୍ୟନ୍ତ। ତ ଇଏ ହେଲା PW7।
my lord.
ତାପରେ ପଳେଇ ଆସନ୍ତୁ ନେକ୍ସଟ ୱିଟନେସ୍ ଟା ହେଲା
10.
PW10। ପଳେଇ ଆସନ୍ତୁ। ନାଇଁ
10.
ନାଇଁ ନାଇଁ,
ମାନେ ଏଇ ଯୋଉ
ୱିଟନେସ୍
ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ ର ଯୋଉମାନେ
ଚାରିଟା ହବ, ଆମେ ସେଇ
My lord, 10. 10.
10 ଆସନ୍ତୁ।
Page 79, 81.
Just এই এক্সট্রা জুডিশিয়াল কনফেশন পার্ট কু পড়ে আছেন।
My lord.
হুম পেজ 79 ର ଲାଷ୍ଟ ଲାଇନ୍ ଆରମ୍ଭ କରନ୍ତୁ। ବଟ୍ ଦି ଆକ୍ୟୁଜ ଡିଡ୍ ନଟ୍ ଗିଭ୍ ଏନି ରିପ୍ଲାଏ। ଏଇ ଯୋଉ ଯାଉଥିଲା ୟା ପଚାରିଲେ ହଁ, ଆଚ୍ଛା ଏଇ ତା ପୂର୍ବ ସେଣ୍ଟେନ୍ସ ପଢନ୍ତୁ ନହେଲେ। We doubted about the foul play। ଏଇ ଯୋଉ ଘୋଡେଇ ଘାଡେଇକି
My lord.
ଯାଉଥିଲା,
If the
ହଁ, କଣ?
accused did not give any reply.
ହଁ at about 2 PM ଯୋଉଟା ତାପରେ
ହଁ ଲାଷ୍ଟ
At about 2
ହେଲା ପଢନ୍ତୁ।
p.m., the accused alone returned back from the hillock, covering his body with a towel, having another bag on his back. We doubted about some foul play and asked the accused after detaining him, but the accused did not give any reply. And when we found blood stain on his wearing apparel, we threatened him to call police, and hearing name of the police, the accused discloses before us that he had murdered the deceased by means of a knife on the hillock by cutting his throat, and thereafter burnt the dead body by means of dry leaves. Hearing this from the
Same
accused,
ଜିନିଷ ପୋଲିସକୁ
From
ଡାକି
in chorus. It is a chorus.
ସେମ୍ ଥିଙ୍ଗ କଣ ବାହାର କରିଛନ୍ତି କ୍ରସ ଜାଣିଛନ୍ତି ପାରା
it is not a fact that the accused did not disclose before us that he borrowed 10,000 from the deceased and that when the deceased asked him for repayment, he murdered the deceased.
କିଛି ତ ନାହିଁ ଖାଲି ଡିନା
Next.
ତାପରେ ହେଲା ଇଏ ଗଲା ଆପଣଙ୍କର 7-10 ଗଲା 11-14 11କୁ ପଳେଇ ଆସନ୍ତୁ
11 ବାବୁଲି ସାହୁ ପେଜ 82
ପଢନ୍ତୁ
ମାଇଲର Miller, when we threatened of the calling police, he disclosed before us.
Same.
I cannot exactly recall the color of the shirt.
Para 7.
Para 7, my lord.
suggestion
It is not a fact that, my lord,
Yes, only that.
on 23/3/2001, I was not enjoying picnic with my friends at Sunakhai and that the accused did not disclose before us that he had borrowed 10,000 from the deceased and when the deceased asked for repayment, the accused murdered him and that I am deposing false.
କିଛି ନାହିଁ ତାପରେ 14କୁ ପଳେଇ ଆସନ୍ତୁ
Informant, page 991. My lord. 921. Informant of the case. We threatened to call police. He did not disclose before us.
କୋଉଠି କଣ
ଚାରିରେ my lord.
91 ର ଲାଷ୍ଟ ଲାଇନ୍ ରୁ ଆରମ୍ଭ କରନ୍ତୁ PW14 on being asked PW page 91 ଦେଖୁଛନ୍ତି ତ
ଆଜ୍ଞା
PW14
ଆଜ୍ଞା
ପୁରା ଲାଷ୍ଟ ସେଣ୍ଟେନ୍ସ ପଳେଇ ଆସନ୍ତୁ on being asked
ମାନେ ତାର ଡିପୋଜିସନ ର ଫାର୍ଷ୍ଟ ପେଜ ର ଲାଷ୍ଟ ଲାଇନ
my lord.
ଲାଷ୍ଟ ଲାଇନ୍ ଟାକୁ ପୁରା କହୁଛୁ ଆସିବା ପାଇଁ
On being, my lord. On being asked about the reason of blood on
He's wearing apparels.
his wearing apparels, he remained silent. And when we threatened to call police, he disclosed before me and others that his name is Barun Behera and the name of the person accompanying him, we Pintu alias
was Pintu alias Priyavrata Pati.
and that he had murdered that Priyavrata Pati knife by
Cutting his throat on the
throat on the hillock. Hearing this from the accused, we informed Kunja Bihari Sahu of village Indupur, who advised us to detain the accused. And after arrival of the Kunja and the police, we all went to the hilltop with the accused, and thereafter the accused led us to the place where he had thrown the dead body of the deceased and set him fire. And on arrival at the
Then
place,
cross examination para 7.
my lord,
Cross examination para 7.
my lord, my lord, para 7. It is a fact that we detained this accused as per advice of Kunja. It is also a fact that we tied the hands of the accused with a napkin, gamucha. Kunja Bihari Sahu also accompanied us to hillock and with the police.
So by the time this confession was made, his hand was not tied. It is only after Kunja arrived, he asked, and thereafter the hands were.
तो सेक्शन एविडेंस एक्ट अच्छी
ଆଜ୍ଞା
सेक्शन 24 पढ़ंतु
ତ ନୂଆଟା ହେଇଛି ସାର୍ ସେକ୍ସନ 22 କନଫେସନ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ ଏଭିଡେନ୍ସିଆଲ ଭ୍ୟାଲୁ ଅଫ
सेक्शन ता पढ़ंतु
ମାଇନର ସେକ୍ସନ ପୁରୁଣା ବହି ପୁରୁଣା ବି ଅଛି
पुराना बहिरे पर ट्रायल टा ହେଇଛି ନୂଆ ବହିଟା କଣ ପଢୁଛନ୍ତି
ନାଇଁ
ତାର କଣ ଚେଞ୍ଜ ଚେଞ୍ଜ ହେଇଥିବ କଣ
ନାଇଁ
ହଁ
24 ପଢୁଛି ମାଇନର ସେକ୍ସନ 24
ହୁଁ
confession caused by inducement, threat, or promise when irrelevant in criminal proceeding.
ହୁଁ
A confession made by an accused person is irrelevant in a criminal proceeding if the making of the confession appears to the court to have been caused by any inducement, threat, promise having reference to the charge against the accused person proceeding from a person in authority.
ଏଇଟା ଟିକେ ମନେ ରଖିଥାନ୍ତୁ ପ୍ରୋସିଡିଂ ଫ୍ରମ୍ ଏ ପର୍ସନ ଇନ୍ ଅଥରିଟି ଏଟାକୁ ମନେ ରଖିଥାନ୍ତୁ ତାପରେ threat ଏଠି threat କଥା ଆସୁଛି threat having reference to the charge against the accused
Yes.
ହେଲା
My lord.
ତାପରେ in the opinion of the court to give the accused
Person grounds which would appear to him reasonable for supposing that by making it he would gain any advantages or avoid any evil of a temporal nature in reference to the proceeding against him.
ତାହେଲେ ଯଦି ମତେ ଧମକ ଦିଆଗଲା ଏବଂ ସେ ଆକ୍ୟୁଜ କୁ ଧମକ ଦିଆଗଲା ଫ୍ରମ୍ ଏ ପର୍ସନ ଇନ୍ ଅଥରିଟି ଆଉ ସେ ଧମକରେ ସିଏ ଭାବିଲା ତାର ଗୋଟେ ଇମ୍ପ୍ରେସନ ଆସିଲା ଯେ ମୁଁ ଯଦି ଏ କନଫେସନ ଟା କରିଦିଏ ତାହେଲେ ମୁଁ କିଛି ଆଡଭାଣ୍ଟେଜ ପାଇବି ବା ମୁଁ ଏଇ ଯୋଉ ବିପଦରେ ପଡୁଛି ତା ଦ୍ୱାରା ମୁଁ ଖସି ଆସିବି ଏଇ ଭାବ ନେଇକି ମୁଣ୍ଡରେ ତାର ସିଏ ଯଦି କନଫେସନ କରିବ ତାହେଲେ ସେ କନଫେସନ ଟା ଭଲ୍ୟୁଣ୍ଟାରୀ ନୁହେଁ that would be irrelevant in a criminal proceeding ତ ଏଠି ସେମାନେ କନଫେସନ କରିବାକୁ ଯୋଉ ଗାଁ ଲୋକ 3-4 ଜଣ ଏମାନେ କିଛି ବାଧ୍ୟ କରିନାହାନ୍ତି ସେ ଖାଲି ଦେଖିଲେ ତାକୁ ଯେ ଇଏ ଏଇଭଳି ଅବସ୍ଥାରେ ଯାଉଛି ରକ୍ତ ଇଏ ପିନ୍ଧିକିନି ତାକୁ ଅଟକେଇଲେ ଇଏ କରି ପୋଲିସକୁ ଡାକିଦେବୁ ବୋଲି କହିଲେ ଦ୍ୟାଟ୍ ମଚ୍ ତାପରେ ଯାହାଟା ସିଏ କହିଛି ଏଟା ସ୍ୱତଃପ୍ରବୃତ୍ତ ଭାବରେ କହିଛି ତ ସେଇଟା କହିବାକୁ କୁହାଯିବନି ଯେ ତାକୁ ଏମାନେ ଥ୍ରେଟ୍ ଦେଇକିନି ସେ କନଫେସନ ଟା ଆଦାୟ କରିଛନ୍ତି ବା ତାଙ୍କ ପାଖରେ କନଫେସନ କଲେ ସେ କିଛି ଆଡଭାଣ୍ଟେଜ ପାଇଥାନ୍ତା ଯୋଉଥିପାଇଁ ସିଏ ତାକୁ କହିଲେ ଯେ ତୁ ମାନିଯା ତତେ କିଛି କରିବୁନି ଏମିତି କିଛି ନା ଧମକ ଦେଇଛନ୍ତି ନା ପ୍ରମିସ କରିଛନ୍ତି ନା ଇଣ୍ଡ୍ୟୁସମେଣ୍ଟ ଅଛି ସେମାନେ ଖାଲି ଟ୍ରାଏଲ କୋର୍ଟ ବି ସେଇ ଜିନିଷଟା କହୁଛନ୍ତି ଯେ ଖାଲି ଥ୍ରେଟ୍ ଦେଲେ ତୁ ପୋଲିସକୁ ଆମେ ଜଣେଇ ଦେବୁ ତେଣୁ ଏତିକି ଯଦି ହେଲା ତାହେଲେ how it would attract those hurdles which are there to make it irrelevant or not acceptable in the eye of law.
କଣ ଅଥରିଟି କିଛି ଅଛି
ମାନେ ଯେତେବେଳେ ତାକୁ କହିଛନ୍ତି ଧମକ ଦିଅନ୍ତି ପୋଲିସ କହିଦେବି ଏତିକି ସେ
ସେ କହିଦେଇଗଲା ସବୁ
ମାଇନର
ଗୋଟେ ଲୋକଟେ ରାତିରେ ଏକ୍ସାମ୍ପଲ ଦଉଛି ଗୋଟେ ଲୋକ ରାତିରେ ସନ୍ଦେହ ହେଇକିନା ଆସୁଛି ସନ୍ଦେହ ଭାବରେ ଇଏ କରି ଆସୁଛି ରାସ୍ତାରେ ତାକୁ 3-4 ଜଣ ଲୋକ ଅଟକେଇଲେ କହିଲେ କି ରାତିରେ କୁଆଡେ ଯାଉଛୁ କୁଆଡେ ଯାଇଥିଲୁ this much they have said सी कहला जे एमती भाई एठी जाइली एमती से लोकटा को मर्डर करदेली ये टाइप रो फाइला तो से मान कोन ताकू कन्फेशन करिया पे बाध्य करथिले थ्रेटनिंग देइथिले इंड्यूसमेंट करथिले प्रॉमिस करथिले कि
Here, my
पचारे
lord,
जे
if you do
वाड़े
approach,
वाड़े
here, my lord, पुलिस की कहीदेबु ये जो भयटा देखैले
पुलिस को कोई एटा भय
पुलिस की डाकी देबु
ना पुलिस को डाकी देबा एटा भय
हाँ सर काले कौन कर देबु
मान
तेणु से 80
who will give protection
my lord
in case of any eventuality? Who gives protection?
Rather, you would have protected by police, anything would have happened on threaten or coercion. यदि पुलिस ऐसे ताकि प्रोटेक्ट दो ना
threatening to the extent of making the confession, tahale that would be irrelevant. And that he would be in a state of fear and or he would feel that if I disclose, then I will gain some advantage or these persons will help me or I will avoid the evil, all these things. So that should be from the also the from the a person of the what they say authority. But এই সিচুয়েসন রে जो आसीची गां लोक ताको अटकैचंदी देखिचंदी संदेह करिकिनी ताको कहले पुलिस को डाकी दबो दिस मच दे हैव सेड तेणु
Moreover, what is the nature of the witnesses? These witnesses are chance witnesses.
my lord
They are not witnesses against this crime. They were having their picnic party. On the way, they found this man because while going, they had seen two persons had gone. While returning, only one person is returning with a suspicious manner.
my lord
That is how it was their curiosity to know how is that one man is returning with such a gesture and appearance, having stain of blood in his wearing apparel. That is how they cannot suppress their inquisitiveness to know about him, and they asked whether the very fact telling to the witness, the accused, that they will call the police would amount to threat. এটা তো ଆଉ କଣ
my lord
ନାଇଁ ସେମାନେ ଯୋଉ କହିଲେ ଯେ ଆମେ ପୁଲିସ କୁ ଡାକି ଦେବୁ does it amount to threat?
এটা threat ଆଜ୍ଞା
ଆଜ୍ଞା
এটা threat
ହଁ ସେଇଟା କୁହନ୍ତୁ threat ଟା କାହିଁକି ସେମିତି what is that? ମାନେ ପୁଲିସ କୁ ଡାକି ଦେଲେ କଣ ପୁଲିସ ଅସୁବିଧା କରିବ? Is it an allurement or a inducement? What is that?
So,
ନା ତା ମନରେ ଆସୁଛି
every threat would not
Yes.
be a factor
Factor.
to
within
bring
the
it
this
within
24.
that it would not be acceptable. Threat must be to
Charge.
from the what extent to the charge and it should flow from the person in authority and the impression would be carried by such threat, promise or inducement that if I make the extrajudicial confession that I will get some advantage, I will
immunity or something.
something like that. So ସେଇଟା ନ ହେଇକିନି ଖାଲି ପୋଲିସ କୁ ଇଏ ସ୍ୱତଃପ୍ରବୃତ୍ତ ଭାବରେ କହିଦେଇଗଲା ଯୋଉ ଏକ୍ସାମ୍ପଲ ଟା ମୁଁ ଆପଣଙ୍କୁ ଦେଲି ରାସ୍ତାରେ ଜଣେ ଆସୁଛି କୁଆଡେ ଯାଉଛି କି ସେ ତାର ଗଳଗଳ ହେଇକିନି କହିଦେଇ ଚାଲିଗଲା ଯେ ନାଇଁ ଏମିତି ଯାଇଥିଲି ଏମିତି ହେଇଗଲା ଭୁଲ ହେଇଗଲା ଇଏ ହେଲା ତ ଯାହା ବି କହୁ ତ ସବୁ ମାନିଗଲା ତ ସେମାନେ ତ ତାକୁ କହିନଥିଲେ ମାନିବାକୁ ସେ ଖାଲି କହିଥିଲେ କୁଆଡେ ଯାଉଛି ଯେମିତି ଏଠି ପୋଲିସକୁ କହିଲେ any citation you have brought
my lord
କାରଣ honorable ଯେ ଲର୍ଣ୍ଣେଡ ଟ୍ରାଏଲ କୋର୍ଟ ଯୋଉ citation
my lord.
ସୁପ୍ରିମ କୋର୍ଟର ସେଇଟା ଗୁଡାଏ citation କୁ discussion କରିକିନି
my lord has also I am giving my lord's citation
Hmm.
another occasion my lord has
କୁହନ୍ତୁ.
With due permission, my lord, this is my lord's
The- the- AR 63 Supreme Court, one zero nine four. The mere existence of threat, inducement, or promise is not enough. But if in the opinion of the court, the said threat shall be sufficient to cause a reasonable belief in the mind of the accused that by confessing he would get an advantage or avoid any evil of a temporal nature in reference to the proceeding against him, it would exclude the confession. To exclude the statement as being hit by section 24, the inducement, whether it assumes the shape of promise, a threat, or mere advice, must relate to the actual charge and be such as is calculated to influence the mind of the accused with respect to his escape from the charge. The inducement must be a reference to escape from the charge. पर्सन इन अथॉरिटी ऊपर गुड़ाई डिसीजन अच्छी गाँव रो मनकर सरपंच मुखिया जमीदार
ସରପଞ୍ଚ
गोटे मनकर मीटिंग फिटिंग होता मीटिंग रे ताकू गुड़ाए लोक
ଇନସିଷ୍ଟ କରିଥାନ୍ତେ କହ ଯେମିତି ହେଲେ ତ କହିବାକୁ ପଡିବ।
गुड़ाए लोक आसते गाँ गाँ सरपंच था मुखिया था सामने ताकू प्रेशर क्रिएट कराई था सर्कमस्टांस रे सी कन्फेस करता बुझिले ना
ଆଜ୍ଞା
तो सिचुएशन इज सच दैट इट कैनॉट बी सेड जो एग्जांपल दिया गला दे हिज कन्फेशन वुड बी वॉलंटरी इन नेचर
ଏଇ ଦିଟା ଯାକ ସେଇଆ ଏଇ ଦିଟା ଯାକରେ the accused has been insisted to disclose. Here there is no insistence. Here in both the that is how he has disclosed. So the voluntariness very basis is lost. We cannot, here there is no question of insistence. ତାକୁ ଡାକିଦେବି କହିଲା ବେଳକୁ ସେ ସବୁ କହି ପକେଇଲା. But here he was detained and insisted in both these cases.
तीनटा जाक जो टर्म यूज ହେଇଛି गोटे इंड्यूसमेंट गोटे प्रॉमिस और थ्रेट
Yes.
से तीनटा को मस्ट रिलेट जे जी भी कला है इंड्यूसमेंट देला जी भी थ्रेट देला जी भी प्रॉमिस कला से एथि पई ताकू देला करिथला ये एक्स्ट्रा जुडिशियल कन्फेशन करिया पे एवं दैट पर्सन शुड बी ए पर्सन इन ऑथोरिटी
Authority.
एवं by causing that impression comes to the accused that if I make this disclosure, I will gain some advantage. I will escape from these charges or I will get some benefit. এই টাইপ ର impression तार भी क्रिएट हवा दरकार एवं सेही माइंड रे जदि से किसी दोष स्वीकार करिगला ताले कहबो जे एटा स्वतः प्रवृत्त भाव रे नुहे वॉलंटरी नुहे एक्स्ट्रा जुडिशियल कन्फेशन वुड नॉट बी रेलेवेंट बट एठी आपनकर जो सिचुएशन हमें देखिले एक तो क्रॉस एग्जामिनेशन किछि नाही जहाँ जो चीफ रू जहाँ आसिला ସେମାନେ ଚାରିଟା ୱିଟନେସ୍ କନସିଷ୍ଟେଣ୍ଟ କହୁଛନ୍ତି ଯେ ଆପଣଙ୍କର ଯୋଉ ମ୍ୟାନର ଅଫ ଗୋଇଂ ଯାହା ଆପଣଙ୍କର ଗେସ୍ଚର ଥିଲା ତାକୁ ଦେଖି ସେମାନଙ୍କର ଗୋଟେ ସନ୍ଦେହ ହେଲା ରକ୍ତ ଲୁକା ଇ କରିଛନ୍ତି ଟାଉଲ ଗୋଟେ ଘୋଡେଇକିନି
ହାତରେ injury ଅଛି।
ହାତରେ ଇଞ୍ଜୁରି ଅଛି ତାଙ୍କର ଗୋଟେ ଡାଉଟ ଆସିଲା ତେଣୁ କହିଲେ ପୋଲିସକୁ ଡାକିଦେବୁ ତାପରେ ସିଏ ତାର କହିଦେଇ ଚାଲିଗଲା ଏଇ ଜିନିଷ
leading to police.
हाँ नहीं सीटा
So
there
that's
are
it.
so many other
Connecting
circumstances.
other
Eita gote-
circumstances are there.
Since you begin with extrajudicial confession, we are pointing out to you. Otherwise, there are number of circumstances in this case. You ଏଇଟା ନେଇକିନି ତାକୁ ଡେଡ୍ ବଡି ଦେଖେଇଲେ ଯୋଉ ଡେଡ୍ ବଡିଟା କି ଗୋଟେ 75% bond condition ରେ ଥିଲା. So how do you explain it? जो पोजीशन रे डेड बॉडी थिला जो पोजीशन रे आपण ताकू नहीं देखैले से डेड बॉडीटा सेटू रिकवरी हैला एवं मेडिकल ऑफिसर स्टेटमेंट मध्ये आसुची जे नाइफ रे इंजुरी हेची नेक रे हेची सफिशिएंट इन ऑर्डिनरी कोर्स ऑफ नेचर टू कॉज डेथ एवं ता छड़ा पोड़ीबा ये रहउची
Accused ପାଖରୁ ମଧ୍ୟ disease ର something that recovered.
There are total how many circumstances? 11 circumstances have been relied upon by the learning trial court. Last scene अच्छी first circumstance होची देइचंदी suicidal nature of death सेटा dispute ने अच्छा से जो 10,000 टंका नहीं थिले लोन
motive ଟା ରହିଲା।
हाँ मोटिव टा तापरे आसिला आपनकर ताकू घरु डाकिन नेले ये न दुई तापरे आपण जाउथिले एकाठी ये देखिले 7 10 11 हाँ
Button ବି ରହିଲା ସେଠି ଦି ଜଣ ଏକାଠି ଯାଉଥିଲେ
हाँ दी
April
जन
12
लास्ट सीन पर
Last
तापरे एकुटिया फेरिला किछि समय परे सेटा गोटे जोठी की एई भली अवस्था रे थिला तापरे आसिला एक्स्ट्रा जुडिशियल कन्फेशन पर लीडिंग टू डिस्कवरी leading to discovery ପରେ ଆସିଲା ଯୋଉ medical evidence ରେ ଯୋଉ homicidal death ରହୁଛି ଏ ସବୁ ଜିନିଷ ଗଲା ତାପରେ ଏଇ ଯୋଉ voter I card କଣ Nokia mobile phone
Cash.
money purse cash 2020
which the deceased was having.
deceased ର Nokia mobile phone ତାର voter I card money purse ଏଗୁଡାକ ଆପଣଙ୍କ ପାଖକୁ ଜବତ ହେଲା
Then you had injury.
and incised wound were found so and so. Doctor opined these injuries can be so and so. So that is how the London trial court has stated that the chain of circumstance is complete.
What is your explanation to the injury?
My lord,
ଆପଣ କଣ explanation? Injury ଯୋଉ ହେଇଥିଲା?
injury the PW 6 Deepak Kar, doctor.
ନାଇଁ injury ତ ଅଛି
That injury may
ଆପଣ
be.
ପ୍ଲି କାହିଁ କଣ injury
That
କାହିଁକି
I plead that I have not mentioned the size of the sharp cut one in this. I did not find any blood stain in the night. Cross examination can be caused by injury number 5 can be possible by falling on the rough surface. Injury to cross examination injury can be caused by
ଆପଣଙ୍କ
ଆପଣଙ୍କ
injury
ଯୋଉ injury ହେଇଥିଲା,
ଦି ଜଣ ଯାକ ୟଙ୍ଗ ପିଲା ସିଏ ଆପଣଙ୍କୁ ଯେତେବେଳେ ଛୁରୀରେ ଆଘାତ କରିବାକୁ weapon of offense
ତାକୁ
is that
oppose
ନାହିଁ
କରିଥିବ ନା
ଅପୋଜ କରିଥିବ ରେଜିଷ୍ଟ କରିଥିବ ସେଥିପାଇଁ ଆପଣଙ୍କର ଇଞ୍ଜୁରି ହେଇଛି ତ ଇଞ୍ଜୁରିଟା ଯେତେବେଳେ ଆପଣଙ୍କର ହାତରେ ଏମାନେ ସବୁ ଦେଖିଛନ୍ତି ପ୍ଲସ୍ ଡକ୍ଟର ବି ଦେଖିଛି ଆପଣଙ୍କୁ ସେ ବିଷୟରେ ପ୍ରଶ୍ନ ପଚରା ହେଇଛି ଯେ ଏମିତି ଆପଣଙ୍କର ଇଏରେ ମଧ୍ୟ ଇଞ୍ଜୁରି ଥିଲା ତାପରେ କଣ କହିବାକୁ ଚାହୁଁଛନ୍ତି କାରଣ ମିଛ କଥା ଖାଲି କହିଛନ୍ତି ଆଉ କିଛି ତ ଏକ୍ସପ୍ଲେନ କରୁନାହାନ୍ତି PW18 is the doctor who examined you on police locution and it
PW
was
6 million.
ଏତେ
PW 13 Dr. Pratap Kumar Das.
କଣ ଆପଣଙ୍କୁ ପ୍ରଶ୍ନ ପଚରାଉଛି ଆପଣ କଣ
ଆପଣଙ୍କୁ କିଏ
କହୁଛନ୍ତି
ଟ୍ରିଟମେଣ୍ଟ କରିଦେଲା?
ଆରେ your injury the injury which appears on the person of the appellant
Million.
and you have been examined by the doctor who is PW18 the doctor PW18 has noticed two incised wounds on the fingers and lacerated wound on the head, abrasions. So trial court
ଆପଣ ମାନିଛନ୍ତି କ୍ୱେଶ୍ଚନ ନମ୍ବର 27 କୁ ଯାଆନ୍ତୁ accused statement ର କ୍ୱେଶ୍ଚନ ନମ୍ବର 27 of accused statement.
your answer is yes.
ହଁ ବୋଲି କହିଛନ୍ତି
ତ ଏଇ ଯୋଉ ଇଞ୍ଜୁରି ଗୁଡା କେମିତି ହେଲା ଆପଣଙ୍କୁ ଟ୍ରାଏଲ କୋର୍ଟ କହୁଛନ୍ତି ଯେ ଯୋଉ ଧସ୍ତାଧସ୍ତି ବେଳେ ଯେହେତୁ ଦି ଜଣ ଯାକ ୟଙ୍ଗ ବଏଜ ଅଫ୍ ଅଲମୋଷ୍ଟ ସିମିଲାର ଏଜ୍ ଥିଲା ତେଣୁ ସେତିକିବେଳେ ଯେତେବେଳେ ଆଟେମ୍ପ୍ଟ ହେଇଥିବ ଇଏ ସେଭ୍ କରିକି ଦ୍ୟାଟ୍ ଇଜ ଅବଜରଭେସନ ଇନ୍ ସର୍କମଷ୍ଟାନ୍ସ ନମ୍ବର ଏକ୍ସ ଆଉ XI କୁ ଯେତେବେଳେ କନସିଡର କରିଛନ୍ତି ପେଜ 31 ରେ ସେ ଟ୍ରାଏଲ କୋର୍ଟ ଅବଜର୍ଭ କରୁଛନ୍ତି
ଆପଣ କ୍ୱେଶ୍ଚନ 28 ରେ ପୁଣି ମିଛ କଥା କହୁଛନ୍ତି ଗୋଟେରେ ହଁ କହିଲେ ଇଞ୍ଜୁରି ହେଇଛି ଆର ଥରେ କହିଲେ ନୁହେଁ
ତ ମୋଟିଭ ଘରୁ ଡାକିକିନି ନବା ବାଟରେ ଦି ଜଣ ଯାକ ଏକାଠି ଯାଉଥିବା ଦେଖାଯିଗଲା କିଛି ସମୟ ପରେ ଆପଣ ଏକୁଟିଆ ଫେରୁଥିଲେ ଯୋଉ ଭଳି ଭାବରେ ଫେରୁଥିଲେ ତାକୁ ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ସେଠୁ ନେଇକିନି লিডিং ଟୁ ଡିସ୍କଭରି ଦେଲେ ସେ ଡେଡ୍ ବଡିଟାକୁ ଡେଡ୍ ବଡିର ଅବସ୍ଥା ଏଇଆ ଥିଲା ତା ଛଡା ଆପଣଙ୍କର ଇଞ୍ଜୁରି ଥିଲା ଆଉ ଆକ୍ୟୁଜ୍ଡର ଜିନିଷ ଗୁଡାକ କ୍ୟାସ୍ ଫ୍ୟାସ୍ ଆପଣଙ୍କୁ ରିକଭରି ହେଲା ଦିସ୍ ଇଜ ଦି ଚେନ୍ କଣ କହୁଛନ୍ତି?
With due respect, a recovery of a cloth
Hmm.
stained with human blood from accused. This cannot be regarded as a conclusive evidence incriminating the accused.
ଗୋଟେ କେସରେ ଆଉ କିଛି ନାହିଁ, ଖାଲି ଗୋଟେ ରିକଭରିଟେ ଅଛି, ଗୋଟେ ଛୁରୀଟା ରିକଭରି ହେଇଛି, ତା ଦେହରୁ ଗୋଟେ ବ୍ଲଡ ଷ୍ଟେନ୍ ଇଏଟା ହେଇଛି, ସେଇଟା ଡିଫରେଣ୍ଟ ମ୍ୟାଟର। ଏଠି ଗୋଟେ ଚେନ୍ ଟାକୁ ଦେଖିବ, ସେ ଏଭ୍ରି that of court a decision in that Sharad Brichand Sardare ସେମାନେ ସେ ଯୋଉ ପଞ୍ଚଶୀଳ ଗାଇଡଲାଇନ ଫର୍ମୁଲେଟ କରିଛନ୍ତି, କହିଛନ୍ତି ଗୋଟେ ଲିଙ୍କ ଦେଖିକିନି ସେ ଚେନ୍ ଟା କମ୍ପ୍ଲିଟ ହଉଛି କି ନାହିଁ ସେଇଟା ଟ୍ରାଏଲ କୋର୍ଟ ଏବଂ ଆପିଲେଟ କୋର୍ଟ ଦେଖିବ। ଆଉ ଆପଣ ଯୋଉ ଡିସିସନ ଗୁଡାକ ଆଣିଛନ୍ତି, ଯୋଉ କେସରେ ଗୋଟିଏ ମାତ୍ର ସର୍କମଷ୍ଟାନ୍ସ ଥିବ, ଖାଲି ଲାଷ୍ଟ ସିନ୍ ଥିବ, ଆଉ କିଛି ନଥିବ, କି ଗୋଟେ ତାର କୋଉ କେସରେ ଆପଣ ଖାଲି ଏକ୍ସଟ୍ରା ଜୁଡିସିଆଲ କନଫେସନ ଥିବ, ଆଉ କିଛି ନଥିବ, କୋଉ କେସରେ ଖାଲି ଗୋଟେ ରିକଭରି ଅଫ ଏ ବ୍ଲଡ ଷ୍ଟେନ୍ ସାର୍ଟ ହେଲା, କି ରିକଭରି ଅଫ ଏ ବ୍ଲଡ ଷ୍ଟେନ୍ ନାଇଫ ହେଲା, so that they have stated that this circumstance alone is not sufficient to hold that the chain is complete. কিন্তু ଆପଣ ଏଠି ଏ କେସଟା it stands in a different footing. ଆପଣଙ୍କୁ ପ୍ରତ୍ୟେକ ସର୍କମଷ୍ଟାନ୍ସ କୁ ଇଏ କରି ତାପରେ ଆଡ୍ରେସ କରିବାକୁ ପଡିବ, ବା ସେ ଚେନ୍ ଟାକୁ ବ୍ରେକ୍ କରିବାକୁ ପଡିବ। ଆପଣ ଯଦି ଯେପର୍ଯ୍ୟନ୍ତ କମ୍ପ୍ଲିଟ ଚେନ୍ ପ୍ରସିକ୍ୟୁସନ ଏଷ୍ଟାବ୍ଲିଶ କରୁଛି, ତାହେଲେ ଆପଣ ସେଇ ଯୋଉ ଶରଦ ବିରଚାନ୍ଦ ସାରଦାରୁ ଆପଣ ବଞ୍ଚି ପାରିବେନି। So you are to break the chain, that ଏଇ ଯୋଉ ଗ୍ୟାପ ଟା ରହୁଛି, it cannot be said that the chain is complete. ତେଣୁ ଆପଣ ଏଠି କୋଉଟା ବ୍ରେକ୍ କରୁଛନ୍ତି, କୋଉ ସର୍କମଷ୍ଟାନ୍ସ ଟା ଆମକୁ ଡାଉଟ୍ କରୁଛନ୍ତି ଯେ ଆମେ ଭାବିବୁ ଯେ ଚେନ୍ ଟା ବ୍ରେକ୍ ହେଇଗଲା, ଏଇ ଲିଙ୍କ ଟା ମିସ୍ ହେଇଗଲା, ତେଣୁ ଏଠି ଚେନ୍ କମ୍ପ୍ଲିଟ ନାହିଁ, ତେଣୁ ଆଉ କିଛି କହିବେ? ଆଉ କହୁନାହାନ୍ତି, ଆପଣ ତ ପ୍ରିପେୟାର କରିବା ପାଇଁ ସମୟ ଦେଲୁ।
ମୁଁ ପ୍ରିପେୟାର କରିଛି ଯେତିକି ପାରିଛି।
ହଁ, ଯେତିକି ଆମେ କଣ କହୁଛୁ ବେଶୀ ପ୍ରିପେୟାର କରିବାକୁ, ଯେତିକି କରିଛନ୍ତି
there is no ocular witness.
କେସଟା ହଉଛି ସର୍କମଷ୍ଟାନ୍ସିଆଲ, ଆପଣ କହିବେ ଆଇ ୱିଟନେସ୍ ନାହିଁ,
ତାପରେ
କିଏ କହୁଛି ଆଇ
ବ୍ଲଡ
ୱିଟନେସ୍?
ଷ୍ଟେନ୍ ସେ କହୁଛନ୍ତି, ବ୍ଲଡ ଷ୍ଟେନ୍ କେତେ କହିଛନ୍ତି ଯେ ନାହିଁ ମୁଁ ଦେଖି ନାହିଁ, ଏ ସାକ୍ଷୀ ସବୁ ଡିସ୍କ୍ରିପେନ୍ସି ରହୁଛି ତାଙ୍କ କହିବାରେ।
କୋଉଠି ବ୍ଲଡ ଷ୍ଟେନ୍ ଅଛି, କିଏ କହିଲେ?
ମାଇ ଲର୍ଡ,
କାହା ଡିଫରେନ୍ସ ହେଲା?
ମାଇ ଲର୍ଡ,
ଆମେ ତ 7, 10, 11, 14 ପଢିଲୁ।
no, there
ଆଉ
are
କାହା?
others.
ଅଦର ନ କୁହ। ହଉ ତଥାପି ବାହାର କରନ୍ତୁ କାହାର।
I mean, PW14 my lord.
Hmm.
It is a fact that
Hmm.
I have not stated before the police that
Hmm.
the accused had covered his head with the Turkish towel, holding an airbag in his eye. The informant Dandapani କହୁଛି
Hmm.
para 9 ରେ my lord.
Hmm.
It is a fact that
ସେ ପୋଲିସ ପାଖରେ କହିନଥିଲା।
my lord,
ହଁ, ଠିକ।
I have not stated before the police that the accused had covered his head
Okay.
with the Turkish. Then my lord,
Hmm.
my lord. Sorry to disturb, my lord.
କିଛି ନାହିଁ ନାହିଁ ସରି କାହିଁକି we are hearing
PW
you.
7 page 71 ରେ ନିଶାକର
Hmm.
is the driver. There is another path. ସେ କୁହନ୍ତି ଗୋଟିଏ path. ସେ କହୁଛି there is another path road from the village Kanarpur to the Kanpur. Jitendra କହିଛି I have no acquaintance with the accused and the deceased prior to this. Then my lord, I come no prima facie acquaintance with either the accused, the deceased. We detained the accused, tied the hands of the accused with the napkin. Then my lord, 9 ରେ କହୁଛି it is a fact that I have not stated before police. My lord, Subhasri Sakusan said to PW2, the daughter, the sister, was this a classmate, and my lord, she had stated that he had taken 10,000. There is no any ଟଙ୍କା 10,000 ଦବା ସେ ଦେଖିନି କିମ୍ବା there is no any document କ'ଣ ଯୋଉ ଟଙ୍କା ନେଲା ବୋଲି କିଛି ପ୍ରମାଣ ନାହିଁ, ଖାଲି ମୁହଁରେ କହିଛି ଯେ ସେ ତା ବାହାଘରକୁ ନେଇଥିଲା. So this PW12 and my lord 16 mother, they have stated so there is no independent corroboration through their evidence that the accused and the deceased were good friends and have taken 10,000 from the deceased. Such their evidence is not acceptable. କିଛି ପ୍ରମାଣ ନାହିଁ. ତାପରେ my lord, there is no one path ସେ କହୁଛି ଇଏ କହୁଛି discrepancy ହେଉଛି. ତାପରେ my lord, PW 17, the police IO did not find any evidence regarding lending of money by the deceased to the accused. He did not make the aunt, ତା ସେ କହୁଛି ଯେ ମାଉସୀ ଘରକୁ ଯିବା ପାଇଁ, aunt for the accused charge sheeted ହେଇନି କି ସେ witness ହେଇନି.
କିଏ ଅଣ୍ଟ
ସେ କହିଲାନି ମୋ aunt କୁ ଟଙ୍କା
ଘରକୁ ପୁରା ସେ ଯାଇ ହିଁ ନାହିଁ ମୋଟେ ଆଉ କଣ ସାକ୍ଷୀ ସେ ତ ରାସ୍ତାରେ ମାରି ଦେଇଛି ତାକୁ.
ବାଟରେ ତ କାମ ବଢେଇ ଦେଲେ ଆଉ ଅଣ୍ଟ ଘରକୁ ଯାଇଥିଲେ ସିନା ଅଣ୍ଟ ସପୋଜ
That was a plea.
ଆଜ୍ଞା
ସେ ପ୍ଲି କହିବାରୁ ସେ ତା ଉପରେ ବିଶ୍ୱାସ କରି ଘରୁ ବାହାରିକିରି ଗଲା. ତ ଏକ୍ୟୁଜ୍ଡ ଉପରେ ତାର କନଫିଡେନ୍ସ ରିପୋଜ କରି ତା ସହିତ ସେ ଭଲେଣ୍ଟାରିଲି ଗଲା, ତା ଡାକିବାରେ ସେ ଗଲା. କିନ୍ତୁ ସେ ଯୋଉ କଥାଟା କହିଥିଲା ଯେ ଆଣ୍ଟ ଘରକୁ ଗଲେ ପଇସା ଦେବି, ସେଇଟା ନୁହଁ, ସେ ରାସ୍ତାରେ ତାକୁ ମାରିଲା.
So with the details I said that when he said we will go to our aunt,
ଯିବା କଥା
without going on to he proceed to here, why not the accused, the deceased,
କଣ ହେଇଥିବ କିଏ ଜାଣିଛି,
କାହିଁକି ମନା କଲା,
କଣ ହେଇଛି
କାହିଁକି
ସେଟା କିଏ ଜାଣିବ, ସେଟା କିଏ ଏଭିଡେନ୍ସ
କୋଉ ବାଟରେ ତାରିଛି, ସେତେ ବାଟ ନାହିଁ, ସେ
କ୍ରସ ରେ ଆଣିଥାନ୍ତେ ନା ଏଇ ବାଟଟା
କ୍ରସ ତ କରିନି, ସେ ତଳ କୋଟ କଣ କରୁଛି, ସେ କଥା
ମାନେ ଆପଣ କି ମୁଁ ନୁହେଁ
ସେ
କେସରେ ଯାହା ହେଇଛି
କ୍ରସ ରେ ତ ଯାହା ମାଇଲଡ ଅଛି,
ଆମେ ତାକୁ ଦେଖିକି ତ କହୁଛୁ ଆଉ କଣ.
ହଁ ମାଇଲଡ ଏତିକି ମୁଁ କହୁଛି there is no eye witness, no ocular, there is no blood stain. I have not, Dr. PW 13, Dr. Pratap Kumar Das, in para 6 correction में कहूँगी, I have not mentioned the size of the sharp cut wound in my report. I 7 ରେ कहूँगी, I did not find any blood stain on the knife. तापर राजकिशोर डॉक्टर कहूँ क्रॉस एग्जामिनेशन रे injury can be caused by lathi, can be possible by falling on rough surface.
ନାଇକା ଯାଇଥିଲା ସି ଏକ୍ସାମିନେସନ ପାଇଁ ହ୍ୟୁମାନ ବ୍ଲଡ ସେଥିରେ ମିଳିଛି ହେଲା, ରିପୋର୍ଟ ଅଛି ପେଜ ନମ୍ବର 110 ରେ. ସି ରିପୋର୍ଟରେ ଆପଣଙ୍କର ଯୋଉ ସାର୍ଟ ପିନ୍ଧିଥିଲେ, ଯୋଉ ପ୍ୟାଣ୍ଟ ପିନ୍ଧିଥିଲେ, ସେଥିରୁ ହ୍ୟୁମାନ ବ୍ଲଡ ଆସୁଛି. Yes, anything you want to say?
Nothing, everything has in a lucid manner had been dealt with by the learned trial court. 11 circumstances has been taken out, 11 has been described in a very possible manner so that the reach at the conclusion that the chain of circumstances is completely clear to remove the charge against the present appellant accused. You are saying that the extrajudicial confession on threat is not. That cannot be a ground to, usually because of their procedures is not available on that. Threat ଯେତେବେଳେ ସେମାନେ ଡାଉଟ୍ କଲେ ଯେ ଜଣେ ଦି ଜଣ ଯାଉଥିଲେ ଜଣେ ଆସିଲା କୁଆଡେ ଗଲା ସିଏ in the normal course something as your lordship was at that point of time Kunjo was called and Kunjo arrived there with the police. In presence of police, police IO stated that they were examining in that hill, and thereafter they leading to the spot where the occurrence was happened, and from that spot everything was recovered.
What ମାନେ କୋଉ ଜାଗାରେ ଥିଲା ସେଟା ଗୋଟେ
Hill up,
ଗୋଟେ କିଲୋମିଟର ସେ ଜାଗା
background, hill up,
ମୁଣ୍ଡିଆଟେ
Monday.
ସେଠି
ସେ knife ଟା ପୁଣି without handle. जो knife ଟା ନେଇଥିଲା
IO ହଉଛି
IO
PW?
I was stated 17.
PW 17 ହଁ
Page 99. Para 2, last word comment. The complainant and other witnesses, namely Kunjavi Sahu, 4G Nella Police, Babuli and others handed over the accused Varun to me on spot. I took the accused to the custody, to my custody. I thereafter seized one black color rain bag containing one Nokia mobile, a money purse with the cash 220, voter ID of the deceased, Priyavartapati, one pant, one turkeys, one towel, one shawl from the possession of the accused Varun. So after the causing the murder, now all these material were with each was in that way. In presence of the witnesses and prepare the seizure list. This is the said seizure list, exhibit 3, 3.1 and 3.4. Next, I arrested the accused Varuna while he was in custody. He also disclosed. Then 27.
No, but how do you explain these things that in the past information report, it is already mentioned that by the time this FIR was lodged, the dead body has already been discovered. Right? So then police came to the spot. So where is the question of again leading to discovery?
27. That means
Fact already discovered cannot be rediscovered as a section 27 of the Evidence Act.
so it is not 27.
Then there is para 4.
FIR ରେ କହିନାହାନ୍ତି କି ଯେ ଏମିତି ଏମିତି ଆମେ ନେଇକିନି ଗଲୁ ତାକୁ
ଆଗେ ଦେଖେଇଲା
ଦେଖିଲୁ
କହିଲା ପରେ ସେ
ଦେଖେଇଲୁ ତାପରେ ସେଠି କହୁନାହାନ୍ତି ଯେ ପୋଲିସ ଏପର୍ଯ୍ୟନ୍ତ ଆସିଯାଇଛି ସ୍ପଟକୁ ବୋଲି କି କୌଣସି ୱିଟନେସ୍ ମଧ୍ୟ ଯୋଉ 4 ଜଣ ସେମାନେ କହୁନାହାନ୍ତି ଯେ ପୋଲିସ ଆସିଲା ପରେ ଆମେ ଗଲୁ କୋଉଠିକି ମାନେ ସ୍ପଟକୁ ସେମାନେ କହୁଛନ୍ତି ଏନି ୱିଟନେସ୍ ୟୁ କମ୍ PW7 let us say PW7 କହୁଛନ୍ତି ଯେ ଆମକୁ ଆକ୍ୟୁଜ ଏଆଇଆ ଇନଫର୍ମ କଲା ତାପରେ ହିୟରିଂ ଫ୍ରମ୍ ଦିସ୍ ଆଇ ଇନଫର୍ମ ୱାନ୍ କୁଞ୍ଜ ବିହାରୀ ସାହୁ
नहीं para 5. PW7 para 5.
ହଁ ପରା ସେ
Thereafter, along with Kunja Sahu and the accused went to the hilltop.
ସେୟା ପରା
So
ତାପରେ
beforehand, na? Before the arrival.
ହଁ ସେୟା ତେଣୁ ପୋଲିସ କଣ କହିଲା ଦେଖୁନାହାନ୍ତି PW ଯୋଉ ଆଇଓ କଣ କହୁଛି ଯେ ମୁଁ ଆସିଲି ସ୍ପଟରେ ପହଞ୍ଚିଲା ପରେ ସେ ଲିଡିଂ ଟୁ ଡିସ୍କଭରି ଷ୍ଟେଟମେଣ୍ଟ ଦେଲା ମୁଁ ରେକର୍ଡ କଲି 20 ୟୁ କମ୍ ଟୁ ପେଜ ନମ୍ବର 99
Again.
page 99 paragraph 2 ର
I thereafter.
on the same day at 4:30 I arrested the accused while he was in custody. He disclosed before me and witness that he committed the murder of the deceased, concealed the weapon of offense, and volunteered to.
So weapon of offense was it?
Achha, thereafter led me witness to the place of concealment of the weapon of offense. Top where the
Yeah,
dead
weapon
body,
of offense.
Achha,
Offense.
ei seidi kochi where the dead body of the deceased was lying in a half burnt condition. The accused brought. Achha, seita hochi weapon of
Weapon
Weapon of
offense ଟାକୁ leading ହେଲା So dead body was shown to the witnesses,
dead body
but weapon of offense was leading
Leading
to
to
discovery.
discovery. ସେ weapon offense ସେ ପାଉଁଶ ଆଉ ପତ୍ର ପୋଡା ଭିତରେ ମଧ୍ୟ
27 ହଉଛି leading to discovery of that weapon. Dead body ଟା already ଆଗରୁ ମିଳିଯାଇଥିଲା. So according to you,
the accused brought out the knife from inside.
That is there.
So it is not a
Dead body
27 is not related to that dead body.
No, that
It
knife.
relates to that
Weapon of
knife.
use, weapon of offense.
ସେଇଥିପାଇଁ ସେ ଇଏରେ ମଧ୍ୟ ସିଜର ଲିଷ୍ଟ ସେଇଆ ଅଛି ଇଟ୍ ଇଜ ଏ ଏକ୍ସିବିଟ୍ 4/1 ଇଜ ଦି ସିଜର ଲିଷ୍ଟ ସେଇଥିରେ ମୋଷ୍ଟ ଲାଇକଲି ଏକ୍ସିବିଟ୍ 4/1 ଟା ଟିକେ ବାହାର କର ଏକ୍ସିବିଟ୍ ନାଇଁ 10 କୁଆଡେ ପଡିଗଲାଣି 2/1 3 ଏଇଟା ଏଇଟା 4 ଗୋଟିଏ ଧାରୁଆ ଛୁରୀ ଯାହାର ଲମ୍ବ 5 ଇଞ୍ଚ ହେବ ସୁଆଂଶୁ ଓସାର ପ୍ରାୟ ଏତିକି ଉପରୋକ୍ତ ମୋକଦ୍ଦମାରେ ତଦନ୍ତ ସମୟରେ ଆସାମୀ ସୁଆଂଶୁ ଉପସ୍ଥିତିରେ ସୁଆଂଶୁ ଘଟଣାସ୍ଥଳରେ ଯାଇ ମୁଣ୍ଡିଆ ପାଖରେ ସେଠୁ ଜବତ କରା so this is only relates to that knife
Weapon of
it's not
dead body.
so according to you this extrajudicial confession is acceptable because this threat was not given to for confession
Rather it will authorize you to treated as a volunteer because you have disclosed. ଯେତେବେଳେ ଡରିଲା କାଳେ ପୋଲିସ ହେଲେ କିଛି ଘଟଣା ଘଟିବ he divulge everything the truth.
all right take it down had Mr. Gokulananda Padi advocate and counsel for the appellant and Mr. Aurobindo Mahanti running additional standing counsel hearing is closed judgment is resolved
Not written note and citation.
you give it kepe
Monday day. Okay, nice.
Tuesday upon the pardon judgment reserved not for you and hearing is closed we learn counsel for both the parties submit that they will file their written note of submission on 2nd of September 2024. This matter on 2nd of September 2025 for submission of the written note of submission and citation. So 2 तारीख रहिला जहाँ written दबा कथा citation so on to बा written note दे देले है ना What about the other matter, Mr. Panda, your matter?
That's it.
Written note.
Short written note.
Mr. Panda has already given, I think.
Citation one is there. Dukha.
Where is that matter?
That item 4.
That has already been given.
Yes.
No, he has to give. Have you give me a copy in here? Give please you.
I am also filing a note. I'll file. So,
This matter will in the judgment.
Your Honor, I am for item 2. Item 2.
Item number 4 hearing is closed. The learning counsel for the state has filed the written note of
I am also filing written note. I'll serve a copy.
Ati file ko Acha. So also the learning counsel for the appellant.
Written note with memo of citation.
Memo of citation. Hearing is closed. Please give it already.
Item 3. May I please, Your Honor? I am for item number 2.
Who will not be taken up to date? Yes. Item 3 कौन?
Item 3, my lord, the report has not found. So I pray my lord.
No, ये सब तो आसिबो ये दिन ना. Common Tuesday 2 तारीख दिन आसिबो.
May I pray my lord let the put in of the Vijay Patnaik Upon Ashram and the SP Kendra may be.
हमें कहीं की कोई वापन स्टेट
Last time, my lord said that if they won't give the report and some action will be taken.
हमें ଆପଣଙ୍କର ଗୋଟେ ଜେଲରୁ ଗୋଟେ ଆଶ୍ରମରୁ ଲୋକଟା ଯାଇ ବାହାରେ ବୁଲୁଛି ତାକୁ ହାଇକୋର୍ଟରେ ବେଲ୍ ହେଇନି
ଆପଣ ଡିଜି ପ୍ରିଜନ କୁ କହୁନାହାନ୍ତି
କି
କାହିଁକି
ଆଶ୍ଚର୍ଯ୍ୟ କଥା
ଡିଜି ପ୍ରିଜନ କୁ କୁହନ୍ତୁ
ସେ କେମିତି ଯାଇକି ଗାଁରେ ଉପସ୍ଥିତ ଅଛି ସେ ବେଲ୍ ଯଦି ହେଇନି ଓନ୍ଲି ଅଲ୍ଟରନେଟିଭ ହଉଛି ଆଇଦର ପ୍ୟାରୋଲରେ ଯାଇଥିବ ନହେଲେ ତାକୁ ଇଏ ହେଇଥିବ ଯୋଉ
Premature
ରିଲିଜ
release।
ହେଇଥିବ ସେତିକି ଆପଣ ବୁଝିବାକୁ 3 ସପ୍ତାହ ହେଇଗଲାଣି ଲୋଡା ଯାଇ ଗାଁରେ ବୁଲୁଛି କେମିତି ବୁଲୁଛି ଆମେ ଆପଣଙ୍କୁ ପଚାରୁଛୁ ତାକୁ ଡାକ ଆପଣ କହୁଛନ୍ତି ଆରେ ଆପଣ କିଛି ବୁଝି ସାରିଲେଣି ମାନେ ଟୋଟାଲ ଇନଫର୍ମେସନ କିଛି ମିଳୁନି
ନା ଇନଫର୍ମେସନ ମିଳୁଛି ପରା ହିଜ whereabouts is there
he is there in the village
but under what
how he went
circumstance
to the village that is ସେଇ ଯୋଉ address ଟା ଆପଣଙ୍କ agree